Welcome to the I Now Pronounce You Divorced podcast, where we have 3 award-winning family law attorneys dive into intriguing topics like divorce, military divorce, custody and visitation, trust and estate planning, and all things family law. Join us as we provide a comprehensive viewpoint through the eyes of our experts and guests, aiming to educate and soothe our listeners. Get ready to tune in because I Now Pronounce You Divorced starts right now.
Hi, I'm Charles Hatley with Malone Hatley PC, where we protect your family, your finances, and your future. Today, I'm joined by Dan and Rebecca, and we want to talk about something that is very often seen, and that is when one parent is blocking your access to the child, or even if you're blocking access of the child to the other parent, what can be done, what you should be doing in that situation, and really, how do you handle that as a whole? It's a very tough situation. When you're talking about, hey, I want to see my child, and you can't, and you don't know what to do. So I want to throw it to you, Rebecca. When somebody's blocking access, when you have another parent blocking access of the child to your client, how do you handle that?
Yeah. So it's going to depend jurisdiction by jurisdiction how quickly you can get in front of a judge and basically have something done about it. But most of the courts that we practice in, you're not going to be able to get on the court's docket immediately unless you can show there's some kind of abuse going on or some sort of harm to the child or something along those lines. And so in that situation, you may have to deal with it for some period of time before you can go to court. And what I always recommend the clients do is document all of their attempts. Hey, can I come pick up the child tomorrow, for a couple of hours? I want to go here or there, or have them come over. Can they come spend the night? Whatever it is, something that's in line with what the parties maybe were previously doing, or certainly wouldn't be unusual. You may not ask to have a newborn come stay over for a whole week or something like that, but something that's appropriate given the child's age and maturity level and all of that. And that way you're showing the court this isn't for lack of trying. This isn't, because I just ran out and refused to come back and only now am I going to claim they've been withholding the child from me. This has been repeated. This is malicious. This is, without any sort of merit. And unfortunately, that's all you can really do in a lot of these cases, unless you have something a little more severe going on.
So you talked about documenting it, documenting the request. What is your best advice to anybody about having to document their requests?
Sure. So using text messages, using email, being able to show phone records of attempts to do phone calls or attempts to do FaceTime calls, anything like that is going to be recognizable to a judge. Now, if you're already using one of these co-parenting apps, that's even better because it provides a lot more data to the court. So the court can see, for example, when a message was sent, whether it was opened, how long it took the other side to respond, and you get a lot more information like that. So if you have parties that are using like Our Family Wizard is one, or any of those other types of co-parenting apps, that's a great way to track it as well. But even just using text messages, just as long as you're putting the requests in writing, they're reasonable, and you can show either the other parent is not responding, maybe they're blocking you or something like that, or they're just outright saying no and coming up with some sort of excuse. You're going to be able to show all of that to the judge that this was attempted again and again and again, and it was denied, and there's no basis for the denial.
Yeah, exactly. It's, trying to put things in writing. Dan, in your practice, when you start seeing the blocking of access to a child, what do you do when the excuses start being, hey, I'm not letting you see the child because last time there was this abuse or last time there was this? Like, how do you handle that?
Sure. And those unfortunately do come up, and it is unfortunate. And if they're going to use the abuse, then what if a client's come to me and they're saying my the other parent won't let me see my child because they're alleging abuse the prior time, then as a practitioner, we need to dig in and see, okay, what happened, if anything even happened. Was there something in writing sent to you that, I saw this cut, I saw this bruise? And there has to be, as Rebecca mentioned, documentation, right? I mean, we can't stress enough regardless of what the situation is. Document, document, document. So if you're on the receiving end and you're being denied because of potential false allegations or just over exaggerating an incident, then you want to reciprocate and document and say, okay, well, if you saw this cut or this bruise or this mark, here's what it was, or here's what happened. But even back it up before it, as soon as there's an incident, let the other parent know, because then you're putting them on notice, and it shouldn't come across you're trying to hide something. But if another parent is alleging because of that abuse, then at that point you have to go talk to an attorney. You want to do what Rebecca suggested, is put something in writing, whether it be a text, an email, even send a message on Facebook. Don't post on Facebook that you're being denied, but just send a message. And I always advise my clients screenshot that, because then if something would happen, you have proof, and send it over to your attorney, or drop it into a folder, send it to yourself in an email, so you have that information. But if you're using those family apps such as our Family Wizard, then it documents everything. And then that other parent, if there was that concern on the abuse, should bring that to the other parent's attention right away, not wait until, because they don't want the other parent to see the child. But unfortunately, in that situation, you have to go and talk. I would highly suggest you go and talk to a lawyer, because then there's other issues involved besides being denied access to the child. Now you're looking at, okay, are there issues with abuse, and how's that going to affect my time moving forward? And so you really need to just hit it head on.
When you're talking to your client, Dan, what do you tell them about how long it's going to take? If there is no sort of fear of an emergency motion or
Sure.
emergency situation, how do you advise a client on that?
It goes back to managing client expectations, and I get it, right? As a parent and you're being denied, you want to see your child right away. But the court systems, as Rebecca pointed out, unless it's an urgent situation, and urgent really is defined as abuse, neglect, or substantial harm to the child, it's going to take time. And it's bad, I get it, but what we need to do is to start documenting that. And I would suggest, if you're talking to your attorney, have that attorney reach out to the side. If they're represented, talk to their attorney and say, listen, here's what's going on. We need to get makeup time, compensatory time. Here's what I suggest. And then if that works out, great. Then I wouldn't suggest filing anything with the court. But if not, then you may have to file something to court. Or what I usually do is draft a motion, send it to the opposing party, and say, listen, if we can't work this out and remedy and rectify this, I'm going to file this motion. We may not be heard for a week or two, but at least you're kind of holding their feet to the fire, and you're moving things in motion. Because then when you get to the court, then you can let the judge know that you try to resolve this amicably. And in my experience, judges don't like parties just running to the courthouse. They want to see, can the parties try to resolve things amicably, at least together. And then where I'm licensed, the gist of the statutes are being able to parent or co-parent together. If not, then you're potentially facing the court saying, okay, well, wait a second. If I don't have mom and dad that can't co-parent, I may change the custody and give one parent more rights essentially than the other one, which would be maybe instead of a joint arrangement, so you have joint physical, joint legal, one parent may get sole legal, and they can make the majority of the decisions for the child. So there's other ramifications that when someone comes in, of course they're going to be upset, and I get it, but let's dig in and let's see what can we do. But then the other side to that is, even if you are in court, 9 out of 10, the judge is going to say, okay, you should not have done that. Slap on the wrist. Don't do this again. But you're setting that stage for, if it happens again, and then it's even more serious. Because I've been on both sides, but it's judge. Listen, we've been here before. We thought we had this worked out. Mom or dad continues to deny my client time. We really need judicial intervention. And then you have additional remedies that are available to you.
So, what is, Dan, your rule of thumb on, hey, I sent a request to the other side to let me see them? How much time do you give them to respond before you do file?
It depends on the jurisdiction and knowing who your judge is. But usually I would draft a motion, send it to the opposing party, and say, if I don't get a response within 48 hours, I will be filing this. Because I think 48 is enough time to where 24 seems a little rushed, in the sense they got to get a hold of their client, figure some things out, and then get back to you. And then that way, when you're in front of the judge, you can say, I gave him 48 hours, although it may be a short period of time, big picture. But when you have a parent who wants to see their child, that's eternity, because that's not 40 hours you're going to see the child. That's just 40 hours that you get a decision to see where do we go from here.
Mhm. And Rebecca, same question to you. How do you decide when and we've all been there, where you're kind of negotiating back and forth, you're trying to reach out to the other side. How
Mhm.
much time do you give it before you say, look, these negotiations are dead. You're wasting our time. I'm going to go file.
Yeah. So I'm a big proponent of starting something with the courts because it takes so long for most of the jurisdictions we practice in to process the paperwork, to assign you a case number, to give you even just what's sometimes called like a status date or something along those lines.
Mhm.
So a lot of the courts where we practice, it could take 6 weeks, 10 weeks, 12 weeks just for the court to process the paperwork and give you an initial court date. When I know that that's going to be a timeline I'm working with, I don't want to push that back even further and spend time going back and forth on a negotiation that may end up failing. I can always, on the flip side, I can always withdraw my pleadings, right? So I'm a big proponent of file now, continue that conversation because I know I have at least 6 weeks to, to engage in those conversations. And then if we do reach a resolution, then we can just submit it to the court as an agreed order and take everything off the docket, or we can remove the case altogether. It just depends on what the parties agree to.
And that's exactly right. When you're talking about an initial filing, right? And an initial filing is where there has been no order entered with the courts regarding the custody and visitation of a particular child. That when you file that initial filing, it is going to take a long time. And once you do file, you can continue to negotiate back and forth. The act of filing in that particular instance doesn't kill your ability to negotiate. And you shouldn't think of it about that way. And then once you do come to an agreement, using that case number to then enter an agreed order so that you can have other remedies if the other parent starts to block access again. I think that's a wonderful distinction. What do you do when there's an order already entered? So let's say there's an order giving dad, or mom this coming weekend, and the other parent withholds the upcoming weekend, and it was like very clear you're supposed to have this weekend starting Friday at 6 o'clock. They withhold it, and a client calls you at 6:01 and says, "Hey, I didn't get to see my child." What do you do in that instance?
Right. So if there's been one violation, you're probably going to reach out to the other side and try to find out what happened. Did they get a flat tire? Is somebody in the emergency room? Are there extenuating circumstances that cause this particular one-off situation? Or is this the pattern? Every time you show up for visitation, there's something and you're just not getting your visitation whatsoever. So once you have an answer on that, then you can decide, do I want to try to modify the order that's in place? So if I have a permanent order, do I want to go back and say, this isn't working, things have changed? Do I want to just hold the other side's feet to the fire and do what's called a show cause, where you're basically asking the court to hold them in contempt for the repeated violations of an order? Or are you somewhere kind of in the middle stage where you just have a temporary order in place and this may be something that you use at your final trial hearing to say, look, the other side didn't even follow the court's order when it came to this temporary order. Why should they be given any more leeway? Why should they be given any more time when this is how they're clearly going to behave? And so it's going to depend a little bit on the where you're at in terms of the case. But usually what we're looking at there is going to be either a modification trying to change the custody order or a show cause where you're trying to enforce that particular court order.
And Dan, kind of same question. When there's an order in place, what are your thoughts about handling the withholding of a child at that point?
Sure. Regardless of where you're at in the case, because those are very good points that Rebecca made, I always have the client call the police, just document that as well. So there's written documentation that the parent did not show up. But then, depending upon where you are in the case, I know in one of the states from licensed in Missouri, we have what's called the family access motion. So that gets you into court a lot quicker. So if you have an order and instead of waiting for a contempt or a motion to modify, you can file a family access motion. And that gets you in the court usually within a couple weeks. But if you're in other jurisdictions, talk to an attorney, and there may be something similar to that. But if not, then it goes back to documenting, and then depending upon how substantial and severe these are. If you're on a temporary order, maybe it's time to revisit that and file the motion to modify or to amend that. And if not, then just continue to document and then use that in your discovery, use that at trial, and then hopefully try to get off from beneath that temporary order. But if it's on the final order, then I would agree with what Rebecca said prior, to where if you have a final order and you've got continuous denial of time, that's when you file your contempt and get that motion filed, because there's other remedies available. You can still try to negotiate, but if it's repetitive, then it's time to file that motion with the court. But if it's a one time, then it's document, talk to the attorney, see what happens, see what we can do. And if we can't resolve it, then I always file as well.
And you talked about calling the police. What happens when you call the police?
Most clients are going to think, oh, something's going to happen. I'm going to get them involved and I'm going to get my child. I can tell you, just in my experience in practicing, police don't want to get involved. They're going to say, go talk to your lawyer, right? And if the parent is withholding and causing harm or danger, yeah, the police will most likely get involved. But if it's just a dispute, as in, I'm being denied time, I can't see my kid, but there's no harm, then the police are not going to get involved, but they're going to have documentation that you called. And that's just further proof to show I was at the pickup spot, my spouse or other parent didn't show up, and I'm just documenting it with the court. So therefore, if it happens again, then you've got this repeat offender and you're showing that you're taking the proactive steps and documenting, and not just sending a text or sending an email saying, where the heck are you? It's, documented from a legal perspective too, where you have the police involved and they can come and say, yeah, dad or mom was here. I made the report. The other parent didn't show up.
Yeah, exactly. And that's kind of been my experience, is even though you have a court order that isn't enforceable, the police don't want to get involved in that. They're not going to go pull the child physically away from the other parent and drag them out, throw them into your car. But there are extreme instances. I had a case one time where my client met mom up in New York, and he was wise enough, him and I had talked about putting an air tag in the child's bag. And he watched the air tag. Everything seemed fine. He went to sleep. He woke up. Mom was going to have visitation overnight in a hotel. He woke up and saw that air tag going down 95 down to mom's home in Florida. And so we were able at that point to call the police because mom had taken the child across state lines. And that is a big distinction, where we had an order that said mom gets one overnight, return the child. We had put it all in writing through text messages. And fortunately, we'd used the AirTag tracking thing to be able to track the child going down 95. And the police stopped mom somewhere in Georgia. And I advised dad, I said, hey, man, just start going down to following mom. Eventually the police will catch up. And that way your child isn't too traumatized by having to sit in a police station too long. And he did. Police caught her in Georgia or something. 3 hours later, he showed up and was able to pick his daughter up. But that was because we had been very proactive in that particular situation. So, Rebecca, what are your thoughts on tracking devices on children?
Yeah, so this is something that I think has obviously increased in popularity quite a bit. And you'll see a lot of parents just every day, they put one in their kid's backpack. They want to make sure that they're at school. They want to make sure they're going where they're supposed to for their after school activities and all of that. So it kind of doesn't need to be malicious. It doesn't need to be, really a big deal, because this is something that other parents are doing anyway, just to keep their children safe. It's a really simple thing, to buy and set up and all of that. And so I think we're going to see a lot more in the way of bringing in AirTag records, to show, was the other parent on time picking them up from school or from their extracurricular activities, or, did the child actually spend time at the other parent's house, or did they go get dropped off at grandparents' house for the whole weekend? I think we're going to see a lot of that type of evidence come up in custody cases, and I don't really see any major issue with it, aside from trying to argue about, oh, well, it was the backpack, that was here and the child was there, and I don't know. So we could have some back and forth on that particular issue, but I think this is something that's ultimately going to be really beneficial in these custody cases, where it's he said, she said, and the court's trying to figure out who's telling the truth and who's motivated which way. This is just going to be another piece of evidence that we can bring in.
Yeah. The same question to you, Dan. I mean, what do you advise your clients, and how do you feel about using tracking devices on children in that way?
I like it. It allows the parents to hopefully have that peace of mind to where, okay, my child is here. I was told they were going to be here and I feel better. But as the child gets older, I think you even have more peace of mind as they get into those teen years to where they're maybe saying they're going to one place but go really end up in another place. And iPhones have tracking devices too. And they're really, I was just talking to a colleague of mine, and she has this interesting case to where the child kept sneaking out of mom's house. But mom kept saying, "Oh no, that never happens here." But yet they have it on the iPhone of saying, "Oh well, wait a second. I see it's 2 a.m. and there goes the child, and the child is going to see her boyfriend." And mom is either oblivious, doesn't care, whatever the case may be. So now you have these concerns of, well, what really is happening at mom's house, and is it in the best interest of the child to be there? And so tracking devices will continue to play a wonderful tool in helping courts really navigate kind of that he said, she said. Hi, this is Dan Cuneo with I Now Pronounce You Divorced. Thank you for taking time to listen to this week's podcast. Please join us next week for part 2.
Thank you for tuning in to our podcast. If you found this episode helpful and you want more informational content, please be sure to subscribe and join us on all major social media platforms, including YouTube. Stay connected for more exciting updates and tips.